right, so welcome everyone to another CIPIL seminar. Very happy to welcome and be able to host Professor Margo Bagley, Emory University in the United States, who is CIPIL visitor for this month, so like now the second period of two periods, and who's going to talk to us today about a tale of two treaties. Number one, the WIPO Treaty on disclosure of origin in the context of traditional knowledge or genetic resources and associated traditional knowledge. But then there's also this Design Law Treaty, which where I'm much less familiar with. So I'm very interested to hear how these treaty regimes relate to the question of disclosure. And Margo has some, I think, quite inside views on that, because you've been advising the African Union on that and have been working on genetic resources, traditional knowledge. And I think some years ago we had you discussing digital sequence information in that context. I'm not sure how much that features in here, but I might have a question on how the two issues are interrelated or not at some point later on. But in any case, I mean, so much from my side. I'll be sort of, handing over to you. I think we'll take questions, including from the audience. So those of you who are online and want to ask questions, please feel free to post them in the Q&A. We'll address them. You can post them whenever you want, but we'll address them after Margo's talk. So Margo, thanks a lot for being here, and over to you. Thank you.
Thank you so much, Henning, and good evening, everyone. I'm just delighted to be with you to talk about these two newest WIPO treaties. And I understand that you've actually heard a bit about the first treaty, so I'm thinking maybe I can speed that one up a little bit to get to the Design Law Treaty. But I wanted to start off with and tell you where I'm planning to go with the talk this evening. First, I want to briefly introduce both treaties, and then take a step back and get to how we got them, and how their trajectories ultimately intertwined, and how we really wouldn't have gotten one without the other, interestingly enough. So in brief, the first treaty is the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge, the GRATK Treaty, which doesn't have a host city in its name. It's the WIPO Treaty, and it was so controversial, it appears countries thought that it was likely to fail, and therefore nobody wanted to host it. Like, there were 3 different countries that like, yeah, we'll host it, and then like they backed out. Oh, we're having elections. And, oh, well, we'll host it. No, and so it ended up just being at WIPO headquarters, and that's why it's called the WIPO Treaty. And its key feature is a disclosure provision for genetic resources and associated traditional knowledge in utility patent applications. The next treaty is the Riyadh Design Law Treaty that was adopted in Riyadh, Saudi Arabia in November 2024. So it actually gets a city name associated with it. It was advertised as a formalities treaty, though it actually had some substance, as we will see. And it's supposed to make it easier for designers to obtain protection in multiple countries by simplifying filing procedures. But as we'll see, there is more to it than that. And a key feature was limiting what a country can require an applicant to disclose. And so that's where we will see disclosure comes into play. These treaties are both groundbreaking for a couple of different things. Both mention one or more of genetic resources, traditional knowledge, traditional cultural expressions, and indigenous peoples and local communities, all of which have been contentious additions to the normative agenda at WIPO, and they both have disclosure of origin provisions, one mandatory, the other permissive. So for the WIPO GRTK Treaty, in terms of how we got here, briefly go back, of course, the CPD, familiar with that, 1992, says that countries have sovereign control of the genetic resources within their border, but they should endeavor to make access available on mutually agreed terms and with fair and equitable sharing of the benefits that come from the use of those genetic resources and associated TK. And while the CBD is about biodiversity and sustainable use, it also is about addressing biopiracy, which has been defined as the patenting of inventions based on biological resources and or traditional knowledge extracted without adequate authorization and benefit sharing from other countries and indigenous and local communities. A well-known example of biopiracy is the development of captopril, a class of ACE inhibitors for treating hypertension. And this drug and these drugs were developed from the venom of the Brazilian pit viper after it was recognized that people experienced a precipitous drop in blood pressure after being bitten by one of these snakes. The drugs were lucrative, but it's reported that little value went back to the country of origin in relation to their development. The 2010 Convention on Biological Diversity implements the access and benefit sharing provisions of the CBD and has a fairly structured framework for the issuance of, for example, internationally recognized certificates of compliance to genetic resource and associated traditional knowledge users. However, neither the CBD nor the Nagoya Protocol are IP treaties, and there were many countries that did not want to discuss IP issues in the context of the CBD. They said, that's for WIPO, and we're not going to talk about it here. And so what we find is these issues finding their way over to WIPO, beginning with Camille Idris, Director General of WIPO, who in the late 90s created the Global Issues Division, which set about doing a number of fact-finding missions related to TK-TCE's genetic resources. And then in 2000, during the negotiations of another treaty, the Patent Law Treaty, which actually was a procedural treaty, some countries introduced a patent disclosure of origin provision into the PLT. And this created great consternation because, like I said, this was supposed to be a procedural treaty. And this was not an issue that had been discussed, and it comes up very late in time in the negotiations and the DIPCON. And Director General Idris came up with a compromise. He's like, let's take this provision out of the PLT, and we're going to create a new committee called the IGC, the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore. Folklore is another term for traditional cultural expressions being less pejorative. And that's where those issues will be discussed. And they were discussed year after year after year. Really just discussions for around 10 years before getting to text-based negotiations. And they started that in around 2011, the text-based negotiations. But even there was a little agreement. And because each country had the right to have their positions reflected in the text, you ended up with documents that had lots of brackets, lots of alternative provisions, clearly showing no agreement. And because WIPO operates generally on the basis of consensus, a single country could block the adoption of a revised text that was improved in some way. And that happened more than once. So much so that finally the then IGC chair, Ian Goss, in 2019 tabled his own text called the chair's text, which he came to after numerous meetings with different countries, different delegations, and that chair's text actually looked like a real treaty. It didn't have any brackets. It didn't have these various alternative provisions. It looked like something that could move forward. Of course, then the pandemic hit and nothing really happened. I should note, though, that all of this time, there were actually 3 texts that were being discussed. The GR Disclosure of Origin text, which did ultimately lead to the GRATK treaty, but also texts that would actually provide new kinds of IP rights for traditional knowledge and traditional cultural expressions. And those negotiations are ongoing. In fact, next week, we'll have the 50th session of the IGC, where those texts will continue to be discussed. And in interest of full disclosure, I should note that I am deeply involved in these negotiations from 2014, including as a facilitator, as a friend of the chair, and later, and at that time I was expert advisor to the government of Mozambique, and later and currently as an expert advisor to the African Union. So with that background, let's go back and take a look at the key provision of this GRATK treaty, which is this disclosure requirement, mandatory disclosure. And basically where a claimed invention is based on genetic resources, the applicant is supposed to disclose the country of origin of the genetic resources, or if that information isn't known, the source, or if it's based on traditional knowledge associated with the genetic resources, then they're supposed to disclose the indigenous peoples or local communities, or if that isn't known, the source. And if none of that is known, then they have to make a declaration, and that could be under penalty of perjury, to the effect that we don't know basically anything. Also, the provision says that offices are supposed to provide guidance on how to comply with this requirement. There's no obligation on any office to verify the accuracy or authenticity of the disclosure. And the information is supposed to somehow be made publicly available. Unfortunately, it does not specify how, and I'll come back to that a little bit later. The trigger for disclosure was a very controversial, much discussed provision, and it is provided in the treaty that based on, when you say that where an invention is based on genetic resources, that means that the genetic resources and associated TK must have been necessary for the claimed invention, and the claimed invention must depend on the specific properties of the GRs and associated TK. So to give you an example of where I think it would likely apply, here's an example, and this is where you have an invention comprises using neem seed oil extract as a fungicide. And genetic resources are mentioned in the claims and the description. So here in the claim, we see neem oil, extracted neem oil. And it does mention origin. It says neem seeds from Africa. I'm like, Africa is a pretty large continent. Let's be a little more specific, people. But there is on this chart indications, okay, well, was it Senegal? Was it Togo? Was it Ghana? And interestingly, apparently the efficacy of the neem seed oil varies geographically by the level of azadirachtin in the trees. And so it looks like from Senegal, you're going to have the most effective, but you would want that to be disclosed. Okay, so it seems to me that this is a case where the claimed invention does depend on the specific properties of the genetic resource. An example where I would not expect disclosure to be required, this is a novel process for producing a low-fat, high-protein nut paste like a peanut butter. Now, genetic resources are mentioned in the patent, walnuts, pecans, almonds, cashews, filberts, but not in the claim. The claim just says nut, okay, nothing specific there. And that's because this process can be used with any of a wide variety of nuts. It is not dependent on the specific properties of peanuts or walnuts or filberts. So I would not expect disclosure to be required here. Much tougher to identify cases where associated traditional knowledge would be required to be disclosed. This is an example I found. This is a method of making a blue colorant from the juice of the fruit pulp of a particular plant. And why would I think that traditional knowledge might be required? Well, in the patent, it gives a number of names for the plant. And one of them, it says, is in the native language of this particular tribe. And I'm like, how would you know that that's the name for this plant in the native language of this tribe unless you talk to somebody from the tribe? So probably associated traditional knowledge would need to be disclosed here. But I mean, without that kind of a smoking gun, it's really challenging to see how, in many cases, one would know that associated traditional knowledge was involved. So while it is a requirement of disclosure, policing that seems challenging, to say the least. The treaty also mandates the imposition of sanctions for noncompliance. However, while it has a ceiling, no revocation, no invalidation, no unenforceability, it doesn't have a floor. And that is a real problem, in my view, in terms of what minimum does a country have to impose as a penalty. I mean, at least it should say you don't process the application until the requirement is met. And there are many other things. There's so many remedies that we have in law, but it doesn't specify. It just has this kind of really vague language: appropriate, effective, proportionate, legal, administrative, and/or policy measures to address a failure to provide the information. So ultimately, it's going to depend on what countries actually do in practice. And importantly, and why this was able to even be a treaty, it creates no new rights. Okay, it is purely a transparency mechanism. All right, so now let's move on to the Riyadh Design Law Treaty, and then I'll bring them both back around together. So industrial design rights provide protection for the way something looks. Utility patents protect the way it works. So design patent protection, you could get on the appearance of this lovely chair, just the way it looks. And there are so many things that are eligible for design protection. But for a long time, it was really a backwater. It didn't get a lot of attention. But during the smartphone wars, somewhere around 2010, Apple won a $1 billion verdict in the United States. It was later reduced on appeal, but $1 billion largely based on design patent infringement. And in the United States, designs are protected by design patents, but that's just what we call them. Other countries have sui generis industrial design regimes. And that caused a lot of people, a lot of companies to perk up and say, whoa, that's a lot of money. And maybe we should pay more attention to design protection. And we have seen since then an increase in filings for design rights. And design rights are quite powerful because even though in theory, all that you are protecting is the appearance, it allows you to, if you get an injunction, exclude the actual article that is the subject of that appearance. So the Riyadh Design Law Treaty is designed to minimize the requirements that countries can impose on an applicant and make it easier for applicants to obtain protection for designs globally. And they say a lot about, oh, it's going to help SMEs and small designers. And Christine Farley, a professor at American University, did a really close analysis of the draft Design Law Treaty. And she's like, well, this will help large global multinationals. This will help large global multinationals. I really don't see where this is going to help small and medium-sized enterprises. And this treaty was negotiated in a different WIPO committee, the Standing Committee on Trademarks, Industrial Designs, and Geographical Indications. And discussions really started around 2005 on this one. Now, in addition to designs being a backwater generally, they were particularly so in low and middle income countries. So we see in Africa not lots of places where we've got much in terms of design protection, and other low and middle income countries as well. High income countries, yes, design filings. And so it's not surprising, and again, this is from Christine, that we would expect even larger numbers of filings and in other countries, including low and middle income countries, with the Design Law Treaty. And these foreign filings could in some cases become barriers to local designers. So this is the closed list that, like I said, it's been widely touted by WIPO. Oh, it's going to contain a closed list. It's going to make it easier. You're going to know in each country, this is all that can be required for you to provide. And the closed list, yeah, sure, that's fine. No indication or element other than those referred to here and in Article 10 regarding how you communicate can be required. All right. However, in 2014, the African group of countries started to notice that there might be interactions between things they were seeking in the IGC and what was being proposed in the DLT. And they were concerned that this closed list could be problematic, particularly because most design regimes are registration regimes without substantive examination. So registered designs could include uses or adaptations of traditional cultural expressions, traditional knowledge, and the incorporation of features created by genetic resources. And that could create more opportunities for misappropriation. And then indigenous peoples and local communities would have to fight these rights in even more jurisdictions at great expense. So to give you an idea of why this was considered problematic, I want to quickly go through, because they say a picture's worth 1,000 words, a number of pictures of designs that are eligible for protection. You will see actually some registrations, but most of these are not actually protected, or at least I don't know for sure that they are by designs, but they could be. They could eligible, the kinds of things that design rights protect. And that could relate to traditional knowledge, traditional cultural expressions. Here we've got chocolate tablets with indigenous animal drawings on them, and those actually are registered. There's a lot of concern about cultural misappropriation. Chokwe masks, similar mask on a Valentino bag, a US design patent on Ghanaian Adinkra symbols, Louis Vuitton shirts based on Basotho blankets from Lesotho. There are Bradley bags, again, using Adinkra alphabet symbols. Some examples from Mexico where you have indigenous artwork used on mango sweaters, and even Romanian sheepskin vests in the British Museum, and you see Christian Dior using the same thing. And this is actually a registration of a somewhat similar looking vest, Tory Burch copying a Romanian coat. And lots of concerns about these kinds of uses. Again, Louis Vuitton in a chair with a design from a particular Mexican group, artisan group. I gave a talk related to this while this was still the draft DLT in New Zealand some years back, and folks came up to me afterwards from the New Zealand Ministry of Business, Innovation and Employment, and they're like, we have an example for you. And they sent me these pictures of shower curtains with Maori paintings that were profoundly offensive and hurtful to the Maori people, because you're putting these important drawings on these household items. Very problematic. So yeah, lots and lots. And these pictures, Kente design on Christian Louboutin, Paloma bag, so many. And they're hard to search for. I collected these over years, and it was partly because there was such vociferous objection to, well, I guess what I'll have to tell you about in a moment, what the African group did. And there were lots of concerns that, oh, this is just in bad faith. You just want to delay things. And it's like, no, there's some real legitimate concerns here about the possibilities of design protection being used to further misappropriation of TK, TCEs, GRs. So what the African group did was insert into that closed list the possibility of a permissive disclosure, that a country that wanted to could require an applicant to disclose the origin of traditional cultural expressions, traditional knowledge, or biological genetic resources used in creating or incorporated in the design. Like I said, created an uproar, people very upset, because this treaty or this text was thought to be very close to a diplomatic conference back in 2014. They thought the only real issue was technical assistance. And again, there had been a lot of framing, oh, it's just a formalities treaty, it's not a big deal. And so this threw a wrench into the negotiations. Seriously, Ruth and I probably have PTSD, Ruth the Kennedy, because we had to defend the African group position, and it was quite, there was a lot of animosity, to put it mildly, animosity. But there were really valid reasons for the African group taking this position. And it really was to leave policy space. Again, this is not mandatory, not like the GRATK treaty, but permissive for countries who want to be able to require disclosure of origin. And also, there would have been policy incoherence because some countries in the IGC were arguing for mandatory disclosure beyond utility patent applications for other areas of IP like designs. And law always is lagging behind technology. This is a treaty for the future. We don't need to close this off too quickly, especially for countries who may not even have really thought much about design protection because they haven't been getting applications. They haven't modified their laws. They don't know what they might need. And then there actually were at the time a number of countries that had an obligation to require disclosure, at least for TCEs and possibly TK, because of the Swakopmund Protocol, the WIPO, African Regional Intellectual Property Organization, Swakopmund Protocol for the protection of traditional knowledge and expressions of folklore. And then later on, South Africa, which is not in a WIPO, but it has its own law requiring disclosure of origin for TKTCs and GRs. And so it's like, well, wait a minute, if we agree to this, we're closing off basically a key feature of the Swakopmund Protocol that we just adopted not that long ago. Excuse me, probably not surprisingly, there was particular resistance to the inclusion of biological genetic resources in that closed list, even among some low and middle income countries. That has been the hardest to arguably defend or to get people to understand why it matters. And I don't have a slide on it now. How am I doing in terms of time? Yes, I need to.
You can go.
I'm okay. All right.
About 10, 15 minutes.
So in writing about this, any of you familiar with the book Perfume? It was made into a movie. French? Okay, all right. So Perfume is about Grenouille, 18th century. He was born with a very highly refined sense of smell, but no body odor. People couldn't smell him. They were uncomfortable around him. And he set out to develop the perfect perfume that would make people just love and adore him. And he was successful. However, he did it by murdering young women and extracting scent compounds from their body. And so I'm like, well, fast forward to the 21st century, should Grenouille be able to get a utility patent on his new, useful, non-obvious composition of matter? And there's nothing in patent law to say that he shouldn't. He meets the requirements, and yet somehow that feels abhorrent. For the same reason or along similar reasoning, countries who have moral utility or moral objections to the patenting of certain kinds of inventions like human cloning or human embryonic stem cells. Other countries might decide that they don't want to grant rights where genetic resources have been misappropriated. The law has been violated. There has been illegal activity in relation to this particular subject matter. And not surprisingly, with the technological development that we're seeing in relation to biodesign, we are seeing ways in which genetic resources are being used in protectable designs that we probably wouldn't have seen in earlier times. And as I mentioned, the registered design allows the owner to exclude the actual products whose appearance infringes the design. So countries might not want to extend protection to the design of an article made using illegally or improperly acquired genetic resource. All right, so here's some examples of where genetic resources are perhaps more important than in other cases to the appearance of an article. This lamp made from mushroom mycelium, a lamp, 3D printed seat also made from mycelium, and we're seeing so much happening in biodesign. It's really fascinating, beautiful things. Now this is a design not created by a human designer per se, but black textile wastes and mushroom mycelium, which formed this white fungal network, and the fungal network just kind of expanded across this article to create this unique white pattern, okay? This is not someone painting this is the fungus doing this. That's protectable, okay, under design law. Octopus bacteria used to create a zero electricity lamp that glows blue when disturbed. Some more mycelium using to create lamps. Here's another one where 6,500 silkworms are actually helping to make the design of this lamp. They deployed the silkworms as a biological printer. And so they are spinning out silk and it's creating this particular pattern. Similarly, bees actively building upon a form, creating sculptures with the natural texture and shine of beeswax. Fabric or textiles grown from bacteria, yarn from extruded bacteria and fungi. Fermented bacterial cellulose used to create the kimono there, shrimp-derived bioplastic housewares, genetically modified silkworms creating fluorescent silk. And I love this one. So this is a scarf dyed in bacterial secretion. So you just put the fabric, the silk in there, and the bacteria are doing their thing, and you come up with this beautiful design. Each one is going to be unique, okay? So genetic resources, yeah, and design. There's a logic here. There is a reason to care about disclosure of genetic resources in design protection. So and again, with this being an area that is fairly new in the sense that people haven't been using it as much, as certainly not in certain countries, we shouldn't cut off the ability for countries to inquire about genetic resources used in this way. Another way to think about this is the fact that there is a much closer link between utility patent protection and design protection than many people realize. So here, this is a design patent for the protection of a stent, okay? And the claim is just to the ornamental design for a double lumen, catheter as shown and described. And then you've got a utility patent on the exact same stent. In fact, it uses the exact same drawings. So utility, design, same article protected. Of course, with the Samsung and Apple, we had design patents, we had utility patents, both covering the same article. And then when we think about pharmaceuticals, which is where biopiracy concerns often arise, well, you can have design patent protection or industrial design protection on the appearance of a drug, okay? So here's an example, and then there's a utility patent on the same drug, and here we see it, you can find it. So the same reasons why countries wanted the GRATK treaty are the same reasons they may consider requiring disclosure of origin for genetic resources in design application, because those genetic resources can be monetized through the industrial design protection system, just like they can through the utility patent protection system. And that captopril, okay, Brazilian pit viper, we've got a utility patent on it, but this was back in the 70s before companies were really thinking about using designs in this way. But they probably could have gotten a design patent on the appearance of the drug too, just like we see many others. So yeah, quite relevant. All right, so the Design Law Treaty, when the African group introduced that provision, there was discussion for like 2 years and then nothing, because high-income countries refused to discuss it even more in the Standing Committee on Trademarks. They would discuss it only annually at WIPO General Assemblies to see, well, are we going to have a DIPCON? Would not even discuss it. It was very interesting, though ironic, as we will see. So what happened to get a treaty on both the DLT and the GRATK treaty? Well, in 2022, the 63rd UN WIPO General Assemblies adopted a decision to hold 2 diplomatic conferences by 2024, one for the GRATK treaty and the other on the Design Law Treaty. And this was not a coincidence, and this was only possible due to Russia's invasion of Ukraine. For real, for real. People always look at me like, wait, what? Yeah, so what does the war in Ukraine have to do with IP treaties? Well, as I mentioned earlier, in WIPO, consensus is the norm. Voting is frowned upon. But early on in those General Assemblies, the United States, I believe it was, introduced a proposal to provide technical assistance to the IP Office of Ukraine, a proposal which Russia vociferously objected to. And countries went back and forth and back and forth, and they finally said, well, let's vote. And so they started voting. And in fact, they had several votes related to that issue. And there were other diplomats who were, I would say, strategic opportunists who were like, we're voting now. Well, if we're voting on that, maybe we can vote on something else. And so you have folks from low-income countries going to talk to folks from high-income countries, low-income countries wanting the GRATK treaty, a lot of EU countries wanting that DLT. Why is still a bit of a mystery. And they get together and say, if we form a bloc, we would have enough votes, because the folks who were really against the GRATK treaty really was the US, South Korea, Japan, and there were a few others, but that was basically it. So that's what happened. They put forward a proposal for two treaties, two diplomatic conferences. And by that time, folks were getting a little concerned about all the voting going on. And the US says, wait a minute, voting is not what we do here. So we won't block. And, it was adopted by consensus. Let's stop all this voting and we'll go back. And so the decision was adopted by consensus. There is just irony all around at WIPO. But yeah, that's how it happened. We would not have these treaties were it not for the war in Ukraine, because otherwise things would have been consensus. And with consensus, anybody can block. The US was going to block. Japan was going to block. Also, we would not have had it if those high-income countries had not been so, we are not even going to talk about this in the SCT. Because if they had come to the negotiating table and agreed to some disclosure provision or something, or talk the African group out of it much sooner, there would have been no DLT. The DLT would have been done, okay? That would have been a treaty many years before. So there would have been no leverage, okay, to say, well, we'll give you the DLT and you give us the GRATK treaty. Wouldn't have been leverage. So both of those things, really came into play for this to happen. In the diplomatic conferences themselves, the GRATK treaty negotiation was expected to be contentious, not nearly as contentious, I think, and then that's probably because the expectations were most likely to fail. But all in all, I think people ultimately realized it wasn't going to fail, and that's because it was the first one, okay? And if there had been no agreement for GRATK, that would not have boded well for the DLT later that year. So something was gonna go through, yeah. So that's the thing, these are so intertwined, that had to be adopted in order for there to be the DLT. Now, interestingly, the Riyadh Design Law Treaty negotiation was much bumpier. And that's in part because there had been so much advertising. This is just a formalities treaty, nothing to see here, no big deal. And yet when countries started looking at it again after many years, and of course now you've got new people looking at it, they're like, wait a minute, there's some substantive stuff in here. There's a grace period, which is substantive. There is a term of protection, a minimum 15 years of protection. TRIPS says 10, 15 years in a formalities treaty? That's not quite right. And then there were other provisions that would require significant and for many countries undesirable changes to their design law regime. So there was a lot of discussion about a lot of provisions that took, I think, some of the demandeur countries by surprise. And in fact, this led to reservations. We've had recent treaties where there's a article that says reservations and it says no reservations. Well, this one has reservations, okay, for a variety of things. Grace period, a country can choose not to provide a grace period, reservations about representation. It's so many different things. And this is unusual, a resolution at the back of it saying, this means this. Even though it sounds like it means that, it actually means this, or it doesn't stop this, that, or the other. So it was really fascinating to see the disagreement in relation to a number of provisions dealing with this design law treaty. And that closed list is really pretty open. So what did we end up with? A contracting party may require, I mean, there's the other things, but what had been the African group provision can require that an application contain other information, including information on traditional cultural expressions and traditional knowledge of which the applicant is aware that is relevant to the eligibility or registration of the industrial design. So you have explicit mention of TK and TCEs, and you can get GRs in as well through other information. They drew a line. They're like, no, we're not going to have genetic resources in there. You can have it in other information. I'm like, that's fine. That's fine. Other information is very broad, very broad. Other information, as long as it's relevant to the eligibility for registration of the industrial design. So do these two treaties mean that we've got a more inclusive, equitable, and just IP system? Not necessarily. So in the GRATK treaty, it was very symbolically important, but there are a number of things that can prevent it from having any meaningful impact. Possibility of low ratifications. We don't know if it will even come into effect. Right now, all I know of is Malawi has ratified it. It needs 15 ratifications to come into effect. And if those end up all being global South countries, I don't know how helpful that would be either. Moreover, the fact that there are ceilings on sanctions, but no minimum, means that countries could adopt a disclosure regime that has no teeth and that still applicants can fairly easily do what they want with. And it's still difficult to detect accuracy, especially for associated TK, whether someone has disclosed accurately the country that they actually got a genetic resource from. And we need some kind of a portal. There was a provision at one point. I don't think it ended up in the chair structure. If it did, it got pulled out. That talked about a portal at WIPO where these IP offices would all send the disclosed information, okay? And it would be in a searchable database. And that way, members of the public, IPLCs, whoever, would be able to search and see, oh, someone says that in this application that they filed in the UK that they got a genetic resource from India, but do we have an access and benefit sharing agreement? I don't see one. So you need if the disclosure information is only kept in that office, that's not going to be terribly helpful. Because that's what we have now. There are more than 30 countries that have disclosure regimes, but they focus only on their genetic resources. And like China gets more patent applications than anyone, but they have this form and the form is not publicly available. So nobody knows, what's in there. So that would need to happen. And then, Henning, you mentioned DSI. Yes, as technology advances, folks are less reliant on tangible material, more reliant on sequence information. And now we're seeing even less reliant on sequence information because AI can generate sequences, can propose sequence data. So we're just seeing things continuing to move, and that one could expect to make the disclosure of origin of genetic resources less important over time. Not completely unimportant, but as you can see, there are a lot of things that can affect this. For the DLT, it's kind of the opposite problem. So, yeah. And that is because it actually does create rights for design applicants. It is a further ratcheting up of IP protection. And there may be high pressure on low and middle income countries to sign on to the DLT and to sign on without taking advantage of the reservations that are there. These countries often get pressure to sign on to various treaties. So yes, lots of rights in that design law treaty if you do not take a reservation under them. So to conclude, the GRATK treaty is symbolically very important to have mention of this subject matter in a WIPO IP treaty. That does matter. And it could be helpful to directly support implementation of the CBD and Nagoya Protocol and to assist with preventing the granting of erroneously patents that are on novel, not novel or obvious material, but it's going to be particularly difficult for associated TK, and it ultimately depends on what kind of disclosure regime countries actually adopt, whether they put any teeth into it or not, and what, you know, who actually ratifies it. And then we've got the concern about technological advances as well. And with the DLT, it's just really funny now that the fact that these high-income countries refused to negotiate actually made the GRATK treaty, which they did not want, possible. And the inclusion of the permissive disclosure provision possible. So they did have a good bit of success because they say formalities treaty, but some substantive and non-standard provisions were adopted that will contribute to the ratcheting up of IP protections. But there is that policy space for disclosure of origin for TKs, TCEs, and GRs in design. That is an important win for low and middle income countries, though if they don't sign on to the treaty, they've got the freedom to do that anyway. Thank you so much for your attention, and I'd be happy to take any questions.